Welcome. This is the first of 3 videos on venue. In this video, you will see that we are moving from jurisdiction, where our focus was on if the court had the power, the authority to hear the case. And we're moving to venue and related doctrines, which focus on where geographically within the judicial system that case should be heard. So for this first video, we're going to focus on 28 USC 1391. That is the general venue statute. Before we dive into 28 USC, I just want to introduce some terms and some definitions and the authority that is the foundation for each of these terms. We know jurisdiction, 28 USC 1331, 32. Jurisdiction also includes 28 USC 1367 and 28 USC 1441, removal. Venue is going to be found in 28 USC 1391. Transfer is going to be found at 28 USC 1404A. There's one statute that I don't have, which is 28 USC 1406. And that is what to do when venue is not proper, okay? Form non-convenes is going to be discussed as it relates to when venue is proper, but it is outside of the United States. And then at the end of the third video of the series, we are going to address form selection clauses, which are contractual agreements about form selection. Okay. What's the purpose of venue? Congress had 3 main goals when it created our venue statute: fairness, efficiency, legitimacy. Fairness in that hopefully the statute would curb forum shopping, and that's the forum shopping that kind of cheats the rules, right? Kind of cheats the rules, forum shopping. Congress wanted efficiency, and efficiency in terms of what was going to be the vehicle that could be used to reduce the real world difficulties of litigation that oftentimes we don't think about. What's that? Travel and the expense that is related if necessary. Marshaling witnesses. Where are the witnesses? How much subpoena power do I need? How far does my subpoena reach, right? What about documents that I'm going to need to establish my theory of the case? Where are they? What is it going to take to get them transported or copied, or right? So we're looking at ways to support a more efficient system, because by supporting that efficiency, hopefully we are also supporting effectiveness. And the third goal that Congress had in mind was legitimacy, right? It respects local interest by allowing juries to be drawn from the communities that are affected by the claim, right? So it gives members of the affected community an opportunity to actually participate in the resolution of the matter. So fairness, efficiency, and legitimacy. Venue answers this question: which federal district is the proper place for the civil lawsuit to be filed and adjudicated. Which federal district is the proper place for the lawsuit to be filed and adjudicated? That brings us to 28 U.S.C. 1391, which is the general venue statute. And we're going to start with subsection A. Well, what does subsection A say? It says that subsection A tells us that the venue rule governs all civil actions and that venue no longer depends on the old distinction between local and transitory actions. Because historically, courts treated land disputes as local actions and tort or contract claims as transitory actions. With the enactment of 28 U.S.C. 1391, specifically subsection A, Congress has abolished that confusion. Today, venue is determined by statutory connection. Well, what does 28 U.S.C. 1391B say? B is the heart of the venue statute. B is the heart of the venue statute. And I say it's the heart of the venue statute because B is where we get direction on how to determine the three places that venue will be deemed proper. How do we determine the three places where venue will be deemed proper? Well, 1391B1 says venue's proper if it is in a judicial district in which any defendant resides. What if I have more than one defendant? Well, if all defendants are residents of the same state, then we can use 1391B1. Because if they are residents of the same state, then choose a district that is geographically the closest to one of the defendants, and your venue is going to be proper. 1391B2, a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, right? Or if this is a land dispute, where a substantial part of the property that is the subject of the action is situated. Okay. If door number 1 doesn't open or door number 2 doesn't open, then I've got door number 3. What's behind door number 3? Venue is proper if there is no district in which an action may otherwise be brought. That means door number 1 is closed and door number 2 is closed. Then we look at any judicial district in which any defendant is subject to the court's personal jurisdiction. Oh my goodness. Do you see it? We started with personal jurisdiction only to circle back to personal jurisdiction. No better profession anywhere. We've already gone through 1391B1, B2, B3, but if you've watched any of my videos, you know that I like tables. And so I gave you B1, B2, B3 in a different format with a table. So B1 is the defendant resident rule. Where do the defendants reside? B2 is the substantial event rule. Where is the geographical location where a substantial amount of the events either occurred or where the omissions occurred, right? And B3 is the fallback rule. And it's literally just that, a fallback rule. If 1 doesn't work, 2 doesn't work, we're going to fall back to where the defendants can find personal jurisdiction. Are you noticing anything? Have you noticed maybe so far that venue is a defendant focused rule? Very much like removal is a defendant focused rule. Well, yeah, that makes sense, right? Because the plaintiff is the master of the claim. That means that the plaintiff has chosen state court or federal court. Plaintiff has chosen which federal district if they've chosen federal court. Well, if the plaintiff chooses state court, does that mean that the defendant is just out of luck if they want to be heard in federal court? No, we have rules for removal, right? And what if the plaintiff chooses a venue that is so inconvenient for the defendant that it makes it either really difficult or impossible for the defendant to show up to defend themselves? Well, we have a venue statute, and we hadn't gotten there yet, but we've got a rule specifically, 28 USC 1406, that tells the defendant what to do in the event that the plaintiff chooses an improper place of venue. Yeah. 28 USC 1391C defines residence, because if you notice 1391B, we are speaking of where defendants reside, or we're speaking of where personal jurisdiction is had. And we know that personal jurisdiction is also oftentimes looking at where a defendant resides. So what does reside mean for venue purposes? 1391 C1 tells us. These are rules that you're familiar with. A natural person, including an alien that is lawfully admitted for permanent residence in the United States, shall be deemed to reside where? Where they are domiciled. I told you, you'd recognize this. What about this one? An entity with the capacity to sue and be sued in its common name under applicable law, whether or not incorporated, shall be deemed to reside where? Where the defendant is subject to the court's personal jurisdiction, right? Told you, you know these rules, right? A defendant not resident in the United States may be sued in any judicial district, right? And the joinder of such a defendant shall be disregarded in determining whether the action may be brought with respect to the other defendants, right? All of these doctrine work hand in hand to try to create a system where you can get a valid order. What is 1391D? 1391D is the residency of corporations in states with multiple districts, right? Like Texas or Louisiana or California. There's multiple districts. Now that I've identified the state that has personal jurisdiction, and I know I'm going to be in federal court in that state, how do I identify whether or not the venue is proper in the Northern District or the Southern District or the Middle District or the Eastern District? Well, I look to 1391 D1, right? And it explains that for purposes of venue under this chapter, in a state which has more than one judicial district, and in the defendant is a corporation, right, subject to personal jurisdiction in that state, This is what we need to do to determine which district is the district that holds proper venue. Isn't this amazing? You have a question, the statute has an answer. So as we review 1391, we see that we get flexible multi-entry points for venue. What are they? 1391 B1, 1391 B2, and 1391 B3. Fantastic. All right, well, let's keep on moving. Now that we know what 1391 says about venue, how does it look? Right. We know what the words say on the paper, but how does it actually look in practice? Real case, real event, real people. For that, we're going to turn to the Uffner case. Here's the citation, if you want to pull it and read through it as we go. I've identified a few facts that I thought are relevant that we are going to be able to use and apply 1391 B2. Now, we're not going to apply 1391 B1 because this isn't the case for it, or 1391 B3 because this isn't the case for it. We are going to apply 1391 B2 because B2 is generally the statute and the subsection that practitioners rely on when we come to choosing proper venue. So let's start with some real simple facts. We're not going to go too deep, so stay with me, but just some real simple facts so that you can see how the statute is actually applied. We've got three defendants. We have the French insurance company. We have an underwriting manager that's in England, and we have an underwriting agent that's in Georgia, United States, right? Together, these three entities underwrote a marine policy for the plaintiff's yacht. Got it? Three defendants, all from three different locations. So that's why 1391B wouldn't work, because they're not all from the same state, right? So if door number one is closed, let's go to door number two. We're looking at substantial events, right? Well, if you read Uffner, you understand that the trial court didn't look at substantial events or either classified substantial events as something other than the sinking of the yacht. Okay, let's move on. Little bit of detail, but we're not going to go too deep, I promise. Little bit of detail, but we're not going to go too deep, I promise. June 97, Uffner left Puerto Rico. About a mile offshore, we get a fire in the engine room of the yacht. And ultimately, Uffner had to jump ship in order to save himself. And the yacht subsequently sank. So what do? Uffner did what a lot of us do if we have insurance. We call our agent and we file a claim. There's some back and forth for some period of time. Ultimately, the claim is denied. So what do? You file a lawsuit, right? You file a lawsuit. September 20, 1999, September 20, 1999, the trial court dismisses Uffner's complaint. Now, they dismissed it without prejudice, which means that Uffner can file it again, just not in that court. Okay. And if you read the case, you'll see that the trial court dismissed Uffner's case for two reasons. Number one, the trial court held that district in Puerto Rico didn't have personal jurisdiction over the defendant. And number two, venue was improper in Puerto Rico. Now, this isn't a video about personal jurisdiction, but we're going to chat about personal jurisdiction because we can't just have it stand there in our face and we ignore it. But let's try to stay on task, at least for a minute. So if you've seen any of my videos, you know that I've created what I call a fact element map. Here's the fact element map. And this gives us a method of processing what the elements are, what the facts are that either support or negate those elements. Once I wed those together, the fact and the element, I come up with some analysis that leads me to an outcome. For instance, the first fact that I list is that the French insurance company, right, that provides marine insurance has a principal place of business in Paris. I said that I thought that that was important because it has a foreign domicile. And because it has a foreign domicile, that means that it does not reside in any particular place within the United States. Why do I care? I care because 1391C3 says a defendant not resident in the United States may be sued in any district. In any district. So long as what? Did you look at it? So long as the other venue provisions are adhered to, right? This fact by itself does not establish venue in Puerto Rico, but it ensures that the insurance company's status of a foreign defendant does not bar the forum. Does that make sense? Right? So if C3 says, well, just make sure that the personal jurisdiction is good, and for a foreign defendant, they can be anywhere. Let's just go back to it. Let's go back to it. A defendant, this is 1391C, 1, 2, 3, this is 3. A defendant not resident in the United States may be sued in any judicial district. Da, 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 da. Right? So that might help me if I'm Uffner, and my argument is that Puerto Rico is proper venue. Well, what else does that help? Substantial events, right? I hadn't gotten to that one yet, but that's going to start me on the road. Let's just go over just a couple more facts. We're not going to do all the facts because you'll have the chart and you can go through them yourself. And you might choose that other, you might think that other facts are relevant and you can throw them in this chart, or you might have your own way of processing this information and you might not even need these charts. But let's just go for another one. Let's say number 7. The yacht subsequently sank in the same location, which is Puerto Rico. Because if you look at 6, right, I'm saying approximately 1 mile off the coast of Puerto Rico, a fire broke out in the engine room, forcing Uffner to abandon the vessel, right? So that was 6. Why is that fact important? Where is that going to go? Well, that's going to go to 1391B2, right? I said substantial part of the events. Well, how does 7 connect? Well, with the yacht subsequently sinking in the same location. Well, that's going to support my 1391B2 events as well. That's going to support my 1391B2 events as well. So there's a fact chart. What is the issue? 3-point issue for those of you who are taking the uniform bar exam. The 3-point issue under the rule of law, that's under 28 USC 1391B2, Here's the legal question. Was venue proper in the District of Puerto Rico when the triggering event occurred in the waters of Puerto Rico, right? That's the yacht sinking. But the insurance contract was negotiated and issued elsewhere. So, what was the legal question? Was venue proper in Puerto Rico? Right? That's what we're trying to find out. What are the dispositive facts when the triggering event occurred in the waters of Puerto Rico, but the execution and the denial of the contract happened someplace else? Good question. Good question. District Court said, nope, venue was not proper in Puerto Rico. And they said for these two reasons: lack of personal jurisdiction over the defendants and improper venue. Trial court viewed Puerto Rico's connection to the dispute as too remote. In addition, the trial court also concluded that they didn't have personal jurisdiction over these defendants and should not have been able to proceed with the trial anyway. So that's how Uffner lost. Trial court said no personal jurisdiction over these defendants. Trial court said, in addition, Puerto Rico is an improper venue. We are going to take a very small detour. Okay. We're going to look at this personal jurisdiction issue. And I said, this isn't a video on personal jurisdiction. We've got lots of videos on personal jurisdiction, but we can't have this personal jurisdiction jumping up in our face and we ignoring it. So, as to personal jurisdiction, on appeal, the First Circuit immediately disposed of this personal jurisdiction issue. On appeal, right, the court noted that the defendant failed to raise a 12B2 personal jurisdiction defense, right? 12B motions are defensive motions. The appeals court said that the defendant failed to raise a 12B2 personal jurisdiction defense in their first responsive pleading. And pursuant to rules 12G and 12H1A, that meant that the personal jurisdiction defense was waived. Therefore, the appellate court held that the defendants waived their personal jurisdiction objection, and as such, the trial court erred in dismissing Uffner's case on the ground of personal jurisdiction. Stay with me. Don't leave me. I've got 2 more slides on this personal jurisdiction issue. Stay with me. Don't leave me. 2 more slides. Here's one. There is a priority of pleadings when it comes to responsive pleadings in the federal court. There is a priority of pleadings when it comes to responsive pleadings in the federal court. Defensive motions found in 12B go from 12B1 through 12B7. Take a quick look. Subject matter, personal, venue, insufficient process, etc., etc. Here's the last slide on personal jurisdiction. Same motions. You see, I rearranged them. Right? It's now 2, 3, 4, 5. I did that so that you could see that if the defendant fails to file as their first responsive motion the defense, then it's waived. So because the defendants never filed that 12B2 lack of personal jurisdiction, they waived it. And that makes sense because personal jurisdiction can be consented to, right? Now, look down here at number 1. Subject matter jurisdiction cannot be consented to. So this defense is never waived, right? This defense can come up at any point. But for personal jurisdiction, you've got to claim that beforehand, before you file a response, before you do anything else. Because if in fact the court does not have personal jurisdiction, you need to get that case out of that court immediately. You don't want to go to the end of trial only to find out, what? The court didn't have personal jurisdiction, right? So the appeals court in Uffner immediately dismissed the holding regarding personal jurisdiction because since the defendant didn't motion that defense, they waived it. Got it? All right, let's get back to venue. As far as venue is concerned, the appeals court analyzed the language that now appears at 1391B2. The court analyzed the language that now appears at 1391B2. That's the substantial part test, right? And we know what it says. We read it. The appeals court rejected the district court's extremely narrow application of the triggering event, right? The triggering event, and instead applied the sequence of events rule. All substantial events leading up to the claim count for venue purposes. So, according to the appeals court, the sinking of the yacht in Puerto Rico, right? The sinking of the yacht in Puerto Rico waters was a substantial part of the event giving rise to the claim. As such, that made Puerto Rico a proper venue. That pause was intentional because hopefully your light bulbs are just blinking all over the place. Hopefully your light bulbs are just popping off all over the place. Now, real quick before we leave Uffner, note well, note bene, note well. In Uffner, which was decided in 2001, the version of 1391 that was in place at that time put all of these rules for diversity in A and all of the rules for federal question in B, right? All of the rules for diversity were found in 1391A, and all of the rules for federal question were found in 1391B. In 2011, right, after Uffner, 2001, Congress enacted the Federal Courts Jurisdiction and Venue Clarification Act. And in that act, the statute was reorganized and renumbered. The statute was reorganized and renumbered. And so 1391, right, had a single unified venue provision for all civil actions, right? So they put it together. So if you're reading Uffner, the case is going to refer to 1391A, right? But 1391A is now known as 1391B. So I wanted to remove any misunderstanding or any congestion about the nomenclature. Okay. What's the rule statement for 1391B2? You know what it is. Venue is proper in any judicial district where a substantial part of the events or omissions giving rise to a claim occurred, period. Stop right there. You do not need to include in the rule statement the other statements that I've put here, highlighted in red with the citation, because I did that just for your benefit. But the rule statement stops where 1391B2 stops. A judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of property that is the subject of the action is situated. That's your doctrinal rule. Let's go back to slide 26. That's your doctrinal rule. Got it? Okay. What's the conclusion? We're at the end of video 1. How do we conclude 28 USC 1391? Well, we're going to conclude 28 USC 1391 with a focus on 1391B2. Uffner, as it applied 1391B2, demonstrates that the substantial part test is flexible and fact intensive, right? Courts will not require the forum to host the contract negotiation or host the execution of the contract or even host the denial of the claim, right? So long as that venue holds significant events that are tied to the loss that is the subject of the claim. Uffner shows how we apply 1391B2 to matters that can be messy, that may include cross-border factual scenarios. And Uffner shows us why 1391B2 is often the most litigated venue clause, right? Again, Uffner could not have used 1391B1 because all of the defendants were not in the same place. There was no need to go to 1391B3 where a defendant is subject to the personal jurisdiction of the court, because 1391B3 says if 1 and 2 don't work, then come to 3, right? There's a method in the madness. There's a process that we have to follow. With that, we end video 1 of the venue series. Video 2, which I hope you will join me, is 28 USC 1406, improper venue. Until then, be safe and have an amazing time as you learn how to negotiate in the best profession ever.